out of the courtroom claiming that his judgment will be ready on Friday. Meanwhile, in less than 24 hours, a court order was being served on Parliament and Honorable Nyindam. What kind of kangaroo judicial system we having now in Ghana? The judiciary must know that their actions and inactions to serve the interests of whoever their paymaster is has the tendency of destroying our peaceful republic. We will not mince words. They can conspire to call us one by one for a so-called contempt of court. We are criticizing their shameful conduct. We are not afraid. We are ready to be in Nsawam for their so-called contempt. The world will see their disgraceful conduct. We will not sit aloof and allow them to undermine the very rule of law that they are supposed to protect. How can a judge who calls himself a judge sit in court and misconduct himself in such a manner and expect the country to be quiet? Now here is where the matter becomes even more extraordinary. This order, an order with massive political, legal, and democratic consequences, was pronounced without the court's full judgments, as I've stated supra. There were no written reasons, no factual findings, no legal analysis, just a naked directive issued into the public domain. And the whole constituency is now being told that there must be a rerun. I am a practicing lawyer of experience at the bar. I understand that court occasionally deliver rulings with reasons to follow. But such a practice is the exception, not the rule. And it is never acceptable approach when the stakes are this high, when a parliamentary seat hangs in the balance, when constitutional rights are imperiled, and when the vote of thousands of citizens face annulment. For a judge to casually void an entire constituency elections without first ensuring that a complete reasoned judgment was prepared and published is not merely irregular, it is judicial irresponsibility of the highest order. We have carefully reviewed the relevant authorities, including the Supreme Court's decision in Kojoba and Ghana Water Company Limited and another. In that landmark case, the court affirmed a long-standing principle, quote, in the interest of substantial justice, a court may, in limited and carefully circumscribed circumstances, grant relief not specifically sought by a party, but only where such a relief is unmistakably supported by the pleadings and evidence, causes no unfairness or surprise, and brings true finality to the issues properly before the court.